Thank you very much. As Colin said, my name's Julie Wynd from the Department of Environment, Land, Water and Planning, and that's a name change that came into place as at the 1st of January. So for those with a head for acronyms, it's DELP, and we've sort of just been advising people, if you can't remember, it rhymes with help, but we're the former DEPI, former DSE department. We do look after tenures and licensing right across the state. Kathy and I are actually from Loddon Mallee region, which covers Macedon Ranges right up to Mildura, Central Goldfields, Campaspe, Gunawarra. So it's a fairly big area that we cover. Right, so just as a bit of background, the Indigenous ownership of the land, obviously back in Discovery with Captain Cook, part of the Crown land was considered to, let's take a step back. The land was declared to be terra nullis, that was land owned by nobody. However, in 1993, obviously that was determined to be a flawed concept, and the Native Title Act came in and was introduced to apply to all Crown land in Australia. The land was measured and parcelled up to Crown allotments and then alienated from the Crown by Crown grants. Now, Crown grants, as it states there, is freehold certificate of title, freehold land, privately owned property. Some of the land was reserved from alienation for specific purposes and became recreation reserves and roads. And we'll go into a bit more description with the different types of status for water frontages and also reservations. Prior to 1881, alienated Crown allotments went to the centre line of the watercourse. That's the next page, Kathy, sorry. Pardon? Oh, sorry. The beds, banks and frontages of approximately 280 Victorian rivers and lakes were permanently reserved for public purposes. Now, the frontages normally, in today's measurements, are 20 metres, but the Crown frontages may exceed the width of the reservation. The reservation did not undo the Crown allotments previously alienated to the centre of the stream, and if a watercourse is moved, the reservation remains in its 1881 position, sometimes a distance from the stream. And there's another slide that goes into a bit more detail with that. So that was prior to 1905, when the Water Act legislated that all beds and banks are deemed to have remained the property of the Crown. So that's when the boundaries changed from the centre of a streamway back to the high embankment of the actual land itself. Now this is a diagram showing previously where the centre line was in a waterway for any land that was purchased pre-1881. And you can see there that it did actually cover half of the width of the waterway. Then post-1881, you've got a permanent reserve, and then obviously government roads providing access to waterways, which still occurs. And then on the right-hand side, you've got your unreserved Crown land and freehold. Most of the frontages are permanent public purposes reserves. And again, we've got a bit more information with regards to permanent public purposes reserves. The Land Act of 1858 is the latest version to update the specifications with regards to water frontages in particular. The Act details the way in which the land can be managed and used as licensing or leasing for specific purposes. I've got a copy of the terms and conditions for both types of these licences, if anybody's interested in having a look at it. But the two that we use in particular when we're licensing water frontages is Section 130, which allows for licensing for agricultural purposes, and Section 138 under the Land Act allows for licensing for general or miscellaneous purposes. So when we're talking about riparian licences, we're talking about a licence that would be issued under Section 138 of the Land Act, because most of the other licences that we do have are for agricultural purposes. Obviously riparian has a different intent than that, so it sits under a different section of the Act that we use. And as I said again, I've got copies of the terms and conditions of a Section 138 licence. So apart from the Lands Act, the National Parks Act came into being to reserve lands for national parks, and we've also got the Crown Lands Reserves Act. So that was excised off the Land Act and covers specific reserves, and I've got the list there. Recreation reserves, they can be permanent reserves or temporary reserves. They could have locally elected committees of management. They could be managed by councils. You've got public purposes reserves, reserves set aside for education departments, for schools, cemeteries obviously, and public purpose reserves, which also covers frontages. And from our point of view, that's probably a bulk of our workload that we deal with public purposes reserves and recreation reserves. The other two, or the other specifications, can be dealt with by other government agencies depending on who they're listed with. So this is just another map that sort of tries to identify all the different tenures and land status that can apply in a relatively very small area. So we've tried to get a map that actually shows old title, freehold land, which is down here on the bottom left-hand corner. You've got Crown beds and banks. You've got a riparian licence, which is the darker blue of the two blue areas there. The yellow is unused road licences, which the department also issues for agricultural purposes. So you've got a piece of unused road that can be grazed, and that would be issued under Section 130 of the Land Act. We've got Crown land up the top in that pale green, that's the Committee and Management Reserve. So that would normally be an area that is managed by a locally elected Committee of Management. The green area, you've got a little bit of railway line there, so that suggests that VicTrack would probably manage that area. The pink roading is a road reserve that's managed by whichever council. Under their Local Government Act, roading, unless it's licensed through the department, they manage. Now, it might not necessarily be a road that's used as a road, it might not be fenced out, it might not have any distinguishing features of it actually being a road, but if it's on the databases for both the department and for council and it's shaded pink, it's an area that can be managed by council. Okay. So we'll just go briefly into tenures and reserves. The Land Act allows for public land water frontages to be licensed, and again there's a bit of specific information there. The agricultural licences, which is what I was referring to before, so this could be, well previously it was water frontage licences would come under this, unused road licences, were issued under Section 130 of the Act. And again, the purpose of these agricultural licences was specifically for grazing. And as it says there, they were renewed for a period of 5 years with a term of 35 years, and they were all issued back in October 1994, but they have a renewal date of a 5-year period. Whereas the purpose for the riparian management are issued for 5 to 7 years. The miscellaneous licences, the 138, Section 138, are issued for a maximum term of 10 years, and that normally applies for shedding, curtilage to a dwelling. It could be for garden installation for gardens. Anything else that comes under the miscellaneous determination, so that it's not actually an agricultural licence for grazing. Other tenures that are also available under the Act, you've got your unused road licences and leases. So there's an important distinction between licences and leases. A licence is non-exclusive use, so that means, and again there's another slideshow that goes into a bit more detail with that, but the public have the right to enter an area that's licensed, whereas with a lease it conveys exclusive rights, and that means that obviously it's excluded from public access. So they're the main two distinctions between a lease and a licence. And then it says reservations have a committee of management. We've got two examples there, the Bridgewater Caravan Park. which has basically at this stage been rebuilt from the floods that went through in 2011. That is actually Crown land that has the Loddon Shire Council appointed as a committee of management over that area. And the Bendigo Creek Linear Park is Crown land frontage that borders either side of the Bendigo Creek. It's a fairly extensive area. It runs from Kangaroo Flat all the way down to Huntley, and Bendigo City Council are committees of management over that linear park. So we've got a wide-ranging sort of tenure, reserve statuses, licence and committee management arrangements over our areas that we manage. A bit more information on the licensing. And here's the definition that we need to remember, and that is that licences is non-exclusive. So they authorise use of the land and may be revoked at short notice, and they convey other rights such as preventing the public using guns or camping. So if you've got a licence, you are not able to obstruct the public from entering onto that land. They have the right, as fishermen say, for instance, have the right to enter to gain access to any creek or river that they require. But obviously with common sense, camping, lighting fires, rubbish removal, all that sort of thing, should be negotiated if they actually are able to make contact with the licensee. That can sometimes cause problems, of course, and then we have complaints coming in from licence holders who have issues with people unauthorised use of their licensed area, and that's an issue that the department tries to deal with each case specifically as the information comes in. Licences also convey responsibilities. So apart from the fact that you can have a licence and it is for non-exclusive use, you're also expected to maintain the land in good order, keep it free of pests and weeds, and obviously firewood as a resource, sand and gravel is actually to stay on site. Public access on water frontages cannot be denied by the licensee, and the public has a responsibility that the licensed activity is not compromised by the public. So if there are gates and there's stock grazing, then obviously there's an expectation that the gates would be closed once the members of the public had entered onto that particular area. Sometimes that's not the case. And again, that's when the department gets complaints and we need to deal with any issues that might arise from that. Normally that's not the case. The grazing licences are normally relatively well maintained areas with regards to the licensee's responsibilities, but if it is brought to our attention, obviously we will attempt to deal with that. Many licensed areas, however, in the last few years have come into poor condition, and not all the water frontages are occupied or licensed. Are occupied and not licensed. And that's the issue we're dealing with at the moment. We're trying to make some sort of holistic approach in trying to get all landowners to consider the environmental aspects around having a riparian licence, so that the status of the frontage is consistent with, there's a consistent approach with regards to the pests and weeds, and obviously keeping the waterways free of any contaminants from any grazing that might occur on the water frontages. Water frontage licences can be issued for the purpose of riparian management, and these licences limit the use to protect and conserve the riparian area, can include minimal grazing or pulse grazing as it's sometimes known, just to reduce weed and a fire hazard. Reduction in the rent is generally available for riparian management licences, and the CMA projects that include fencing stock out of waterways qualifies for a licence amendment to the riparian management, including bush tender, bush guardian and land care, etc. Riparian management licence purposes, as it states there, it's $1 on demand for riparian management. If it's riparian management and grazing, which was part of that pulse grazing that we were talking about before, the minimum rental is $88. The riparian management and cropping rental calculated based on an area to be cropped. So obviously, as it says there, not fenced from stock. The rent is based on the dry sheep equivalent, and the cropping rate is the yield per tonne on the crop rotation. The grazing is the productivity of the parish, and that's how they determine a rental. That's calculated when the licence application is received, a letter of offer is sent out, and all that basic information is covered in the letter of offer. Amendment of licence from grazing to riparian, there's no fees that apply. The dollar on demand qualifications, I'm not sure if that's very clear up the back. The entire Crown frontage is fenced from stock. So what we've tried to do is just show an example of where fencing would be required as a minimum to benefit from that $1 on demand as a riparian licence. And on the right-hand side, we've got rental based on the Crown land actually grazed. So it's probably not very clear to see from the back, but we have got copies of the information sheet up the back if anybody wants to have a look at it, or speak to Kathy or I later about what actually qualifies for that $1 rental. Some of the problems that we have with water frontages, some of the modern rivers and lake frontages that were granted prior to 1881, some reserved frontages may be nowhere near where the modern river or lakes. They are dynamic. We have flood events. They do move. Grazing or water frontages as licence purposes may no longer be appropriate, which is why the riparian management licences came into being. Boundaries are often unknown or wrongly fenced. That's a common occurrence. And the water frontages have different statuses, tenure and management. And again, that's an ongoing concern for the department. The movement of rivers. We've got a note there that says there's no adverse possession against Crown, and rivers move but reservations don't. So the doctrine of accretion was that if land which is slowly becomes, with the top year, 1981, you can see the water courses in the middle of where the Crown land is. On the second slide down bottom, there's been a slow and gradual movement. So if there has been a change in the water course there, any land which is slowly added belongs to the owner of the land, and then obviously land that's encroached upon by water is lost to the former owner. And where a river course changes through a flood event, boundaries will remain in the same place, and that's detailed in the two right-hand slides. So again, you've got the original water course, and then down the bottom you've got a sudden breakthrough. The course of the river has changed, but the reserve has stayed in the same place.